Hello, I'm David with Arizona MMC, the state's premier Arizona Medical Marijuana Evaluation Center, located right in the heart of Phoenix. The topic today is how federal marijuana laws differ from state laws. Currently, marijuana remains federally illegal. 16 states plus the District of Columbia have legalized medical marijuana, which obviously is in contrast to federal law. So this has put marijuana between a proverbial rock and a hard place. Looking back at what marijuana used to be in the early 1900s, it had a very bright future. It was widely used medicinally. It was part and parcel of the pharmaceutical industry. Hemp, which is the fiber of the plant, was used for, as you can see in this caricature down here, it was used for fuel, paper, and the housing industry. I don't know why it was used for inspiration. I don't get that. It was used for textiles, food, oil, all kinds of things in the auto industry. But in the 1930s, a growing propaganda movement started against marijuana, labeling it as a gateway drug, leading to harder drug use, causing increased violence, increased sexual crimes. And you can see this in the 1936 movie Reefer Madness, which labeled all these myths as overt. All of those allegations have been disproven, in subsequent decades. But at the time, it didn't matter. It worked. In 1937, the Marijuana Tax Act came before Congress and passed. And what it did was put hefty taxes on the sale of marijuana. It really didn't make it illegal, but it made the taxes so hefty that if you didn't pay them, you got put in jail. And the tax was large. It was medicinally, it was $1 an ounce, and it was about $1 per sale. Otherwise, you can see here on the left, this guy Sam Caldwell was the first victim of Prohibition. He was put in jail the same day for selling 2 joints. So he didn't pay some tax he was supposed to. Anyway, within 4 years, marijuana was taken out of the U.S. pharmaceutical market, and it just didn't have a bright future, obviously, anymore. Not a lot happened between 1937 and 1970. All the efforts to bring it back and take away the Tax Act failed. In 1970, the DEA put marijuana into the Schedule I category, although back then it was called something different than DEA, but it was the same. Schedule I might have the lowest number with regards to the scheduling, but it is the most restrictive. So it's like the DEFCON system. DEFCON 4, 5, whatever, they're not so dramatic. Once you get down to DEFCON 1, you're getting closer and closer to nuclear war. Schedule 1 means that the drug has a high abuse potential, has no currently accepted medical use for treatment, and there's a lack of accepted safety under medical supervision. And it refers to drugs like heroin or ecstasy, LSD, and Quaaludes. Why marijuana is still in there is anybody's guess. Before it was scheduled that way, the Assistant Secretary of Health wrote this to Congress. Since there is still a considerable void in our knowledge of the plant and effects of the active drug contained in it, our recommendation is that marijuana be retained within Schedule I, at least until the completion of certain studies now underway to resolve the issue. If those studies make it appropriate for the AG to change the placement of marijuana to a different schedule, he may do so, blah, blah, blah. Well, in 1972, the Schaefer Commission was put together at the cost of $1 million by Congress. They did these studies. They looked at all the current studies. They looked at everything relating to marijuana. And their recommendation back to Congress was decriminalize it. They didn't see all these myths. They debunked them all. Well, everything got ignored. Nixon's administration ignored everything. Even that letter from the Assistant Secretary of Health where it should be reclassified if the research showed it, that got ignored too. So over the next 25 years, basically everything failed to legalize marijuana, even medicinally. So in 1996, California legalized medical marijuana for compassionate use with Proposition 215. And this began to pave the way, change the landscape for the future of medical marijuana in the U.S. You still couldn't get a prescription because remember, it's Schedule I. You can't prescribe that, but physicians could recommend it. And if they recommend it, and in a lot of states that's called a certification, then you can get your ID card and then however the state allows to get your marijuana. Initially, the federal government decided to go after some physicians for writing these recommendations, But the federal court shot that down because it's protection from the First Amendment. So they don't do that anymore. A few years later, Colorado legalized medical marijuana, and then quite a few other states followed down that path. No state really went wild with dispensaries and the medical marijuana industry until 2009. Well, what happened in 2009? Well, before that, President Obama was elected, and he has stated in many videos, interviews, that he is in favor of tightly controlled medical marijuana legalization. So in his administration, the Ogden Memo came out in '09. That is an infamous memo that announced the Department of Justice policy would be to lay off of medical marijuana patients and operations who were in compliance with state law. And it stated that federal resources would not be allocated to investigate and prosecute patients and operations that were in compliance with state law. So once that came out, the medical marijuana industry essentially exploded. Over the next 2 years, LA County and the city of Denver now have more medical marijuana dispensaries than there are Starbucks. So it's if you have an ID card, it's easier to go get marijuana than it is to go get a latte. I mean, how crazy is that? As of mid-2011, now 16 states plus DC have legalized medical marijuana. That's a third of the country. And 10 more states have legalization pending. So it appeared that the federal government was finally recognizing the legitimate medical marijuana benefits. It still remained on the books as federally illegal, but they weren't going to utilize the resources to go after the compliant businesses and patients, or were they? Things changed and the plot thickened in mid-2011. When the governor of Washington was about to sign a bill starting the medical marijuana dispensary program, he wanted to get clarification from the feds. So he sent a letter. Well, the memo that he got back, the letter that he got back, was very different than the '09 Ogden memo. It didn't change the stance on patients, that patients were not going to be sought after individually, but it did say that they might go after dispensaries, they might go after state employees who are processing applications for dispensaries, and it referred to, quote, large-scale manufacturers and distributors. But it didn't clarify what large-scale meant. You know, obviously it would mean a drug cartel or a big-time drug dealer, but did it mean dispensaries? Well, the governor of Washington promptly vetoed the dispensary bill, and then the U.S. Attorney's Office started sending similar letters out to many other states, like Rhode Island, Arizona, Colorado. So the governor of Arizona, Jan Brewer, decided within a few weeks to sue the federal government because she was concerned about her state employees getting sued by the federal government. The memo to Arizona didn't even mention that, but the one to Washington did. So that sparked controversy. You know, the people who live in Arizona knew the law federally when they voted for medical marijuana. So was this a personal agenda the governor's following on, or is it legitimately? So that remains to be seen. But currently, let's look at a comparison. In '09, marijuana was federally illegal. That remains the case. In '09, it was a Schedule I narcotic, and it's still a Schedule I narcotic. It cannot be prescribed. It was legal in 12 states in '09. Now it's legal in 16 states plus D.C. The Ogden memo in '09 stated the Department of Justice was not interested in going after individual patients. That part of the memo has not changed with the new memo. What did change was that in '09, the Department of Justice said they weren't interested in going after state-compliant patients and businesses. That changed. The new memo stated they were interested in going after state-compliant businesses and also mentioned state employees potentially being at risk if they're processing dispensary applications. So things that haven't changed is that recommendations are still okay, but not prescriptions. Patients can still get ID cards in the legal states. Some states have continued with their dispensary programs, such as California and Colorado. Montana is revisiting theirs, but it's still in place. Otherwise, if a patient can't get their marijuana from a dispensary, they can either grow their own, get it from a caregiver, or potentially get it from other patients. It all depends on what the state allows for. So hopefully, in the future, marijuana will be removed from the scheduling system. Currently, there's a bill in Congress to do that. We'll see what happens. Patients hopefully will be able to receive legitimate prescriptions, and dispensaries will become legitimate as what you would call a marijuana pharmacy. Overt legalization, there's so much debate over that. It just could go both ways. and word neutral on it. And all states should really legalize marijuana medicinally. There's so much benefit to patients who have cancer, HIV, severe nausea, vomiting, things like that, Crohn's, the list goes on, hepatitis. Um, it really should be out there for patients to utilize. There's a lot more research necessary. It is very difficult to do research when a drug is a Schedule 1 narcotic. It's hard to get the clinical studies underway, get them funded. All those kinds of things are very tough. Arizona MMC, we're located in Central Phoenix at 16th Street and Bethany Home. If you go to arizonammc.com, you can actually do an online sign up and schedule your appointment right there. Toll-free number, you can just call it 855-AZ-ID card. That's 855-294-3227, toll-free. And the low evaluation fee at the center includes photos being taken at the office, all your documents scanned in, and complete assistance with the online application for your card. So you can get your evaluation in the office, and if you qualify before you leave the office, you'll have your whole online application done and submitted. And you could probably get a card. The current average is 3 to 5 business days from the state, unless there's a problem. And we'll get your medical records for free. There you have it, a little bit of history of marijuana and how federal law is different from state. Thank you very much. I hope you have a great day.